us. And today we want to discuss on a very, very important legal issue. And ladies and gentlemen, you know that we want to discuss about love jihad. And to discuss further, let me invite my close friend from Ahmedabad, lawyer Jeet Bhatt.
Good afternoon, Chandrakant. Thank you for introducing me and having me in this show. I'm also looking forward for this discussion on this interesting topic.
Uh, Jeet, actually, you know that lately, of the last 5, 10 years or slightly more, this word love jihad has been in a lot of news and a lot of controversy, and uh, and so much so that the state governments or certain state governments in India have brought in a separate law to prevent the interfaith marriages. So we would like to know that what this legal aspect of this, is there a validity of this law? Do you think this law is justified? So I think you are the legal brain in between both of us. I will ask this from you to explain the love jihad to our viewers and to listeners.
Yes, Chandrakant, what is we see in news these days that a lot of states are coming up with these acts, passing acts against unlawful conversion of religion. And basically, love, there is no legal terminology as such as love jihad. But what it is understood is that religion is used to convert, and love is being used, and marriage, through marriage, there is a conversion going on in some of the states in India, and which is known as the love jihad. But all these acts which have been passed against conversion speak about unlawful conversion which has been done through fraudulent or illegal means. But it does not in any manner stop the willful conversion of any individual from one religion to another. And it cannot as well, because the right to practice, profess, and propagate a religion, any religion, is a fundamental right of every individual. And it is guaranteed under Article 25 of the Constitution of India, which is subject to certain restrictions, of course. But basically, what Article 25 guarantees to every citizen is the freedom of conscience and free profession, practice, and propagation of religion, which provides that all persons are equally entitled to freedom of conscience and the right to freely profess, practice, and propagate religion, but that is subject to public order, morality, and health, and to the other provisions of the Constitution, fundamental rights of the Constitution. So it is subject to other fundamental rights, and is also not permissible when it is against public order, morality, and health. So these three are the basic restrictions imposed on any individual to practice and profess and propagate his right to religion. But otherwise, right to freedom of religion is guaranteed from Article 25 to 28, wherein the first is the freedom of conscience and free profession, practice, and propagation of religion. The next is freedom to manage religious affairs, and freedom as to payment of taxes for promotion of any particular religion, and freedom as to attendance at religious instruction of or religious worship in a certain educational institute. So freedom of religion is prescribed as fundamental rights guaranteed under Part 3 of the Constitution of India. So there cannot be any law which violates the fundamental rights guaranteed by the Constitution. And if any law which is passed in violation would be declared to be void or would become inconsistent with respect uh, to the extent it is in violation of the fundamental rights. But recently, what we find is that the Uttar Pradesh government has come out with the Uttar Pradesh Prohibition of Unlawful Conversion of Religious Ordinance 2020, in which the conversion, and what Section 3 provides is for unlawful conversion to be an offense. It says that no person shall convert or attempt to convert, either directly or otherwise, any other person from one religion to another by use or practice of misrepresentation, force, undue influence, coercion, allurement or by any fraudulent means or by marriage, nor shall any person abet, convince, or conspire such conversion. So, conversion which is done through such illegal means under undue influence, so by making false representations or by making false statements, if or under coercion, which means by threat or under some fear, or through some kind of allurement of giving monetary benefits or a better life. So all such types of conversion which are done using such tactics is made illegal and an offense under this UP Prohibition of Unlawful Conversion Act of 2020. So this act also speaks about the validity of marriages which are done, and also it imposes restrictions, and also prior permissions are required in order to convert one person from one religion to another, wherein an application has to be made to the district magistrate 60 days in advance, and thereafter an inquiry would be held by the district magistrate through the police. And on the basis of that inquiry, if ultimately it is found that it is done through free will and it is not in any manner an unlawful uh, conversion, then such permission would be granted by the district magistrate. So, uh, this is the basic scheme of this ordinance which is passed by the Uttar Pradesh. But I must also point out that this is not the first uh, anti-conversion act passed by any state in India. There are around 8 states in the country which has anti-conversion laws having, to an extent, similar provisions restricting conversion from one religion to another by unlawful means. And in fact, it would be interesting to know that the parliament also in the initial days in 1954 as well as in 1960 attempted to bring an anti-conversion law at the central national level, but somehow at that time it could not gain majority, and therefore it could not fructify. But there is a legal impediment in creating a national law is because the public order under which these acts are passed is exclusively in the domain of the state, and therefore only the state legislature can enact such laws on anti-conversion. The national, it would not be possible for the central government to come out with a legislation through the parliament. So therefore, there are 8 states in India which already have these anti-conversion laws, and Uttar Pradesh is the ninth state, and there are a couple of more states who are also planning to bring out this anti-conversion law. But the initial acts which were passed by the state legislature in the year 1967 in Madhya Pradesh, those acts were challenged for the Supreme Court, saying that they violate Article 25 of the Constitution, and such acts, therefore, are unconstitutional and cannot be passed by the state government. But uh, the Supreme Court, in the judgment of Rev. Tennis Laws versus State of Madhya Pradesh, delivered in the year 1977, examined the entire issue on this right to practice and propagate one's religion, and ultimately held that it did not include the right to convert others from one religion to another. That there is a right to propagate, practice, and profess one's religion to his own conscience. Through his willful means, he can convert, and there cannot be any restriction. But that right does not include the right to convert others. So there is a difference. I can accept any religion, but that does not give me a right that I can convert others from one religion to another. So that is a restriction which the Supreme Court interpreted Article 25 and said that 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 does not include in Article 25 the right to convert, and therefore any restriction on the right to convert would be well within the permissible limits of uh, powers of the state legislature, and therefore such act which uh, prohibits conversion through unlawful and illegal means can be an offense, and its constitutional validity was upheld, and they were not declared to be unconstitutional. So, what I would just like to read a couple of lines from what the Supreme Court uh, 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 has summarized. I quote that it has to be remembered that Article 25, subclause 1 guarantees freedom of conscience to every citizen and not merely to the followers of one particular religion. And that in turn postulates that there is no fundamental right to convert another person to one's own religion. Because if a person purposely undertakes the conversion of another person to his religion as distinguished from his effort to transmit or spread the tenets of his religion, that would impinge on the freedom of conscience guaranteed to all the citizens of the country. So this is what the Supreme Court held, and also why the Supreme Court permitted these anti-conversion law was because it holds that Article 25 stipulates that the right is subject to public order. The court also found that the acts clearly provide for the maintenance of public order. For if forcible conversion had not been prohibited, that would have created public disorder in the states, and that the expression public order is of wide connotation. On the question of competence, the court found that the acts fall within the purview of the states pursuant to entry 1 and list 2 of the Constitution's 7th schedule and are not regulated as a subject of religion, which is under the residuary jurisdiction of the central legislature. So this is how the Supreme Court in 1977 found certain anti-conversion statutes passed by Madhya Pradesh and Orissa states as constitutionally valid and permissible. With respect, so therefore there is no wrong or there is no unconstitutionality with respect to passing of anti-conversion law. So with respect to this act, which section 3 also provides that any conversion through unlawful means would be an offense and would not be permissible, I don't, in my opinion, I don't find that provision to be constitutionally unvalid.
So, Jeet, thank you very much for explaining the legal implications and the legal aspect about love jihad. I think, as a layman, I feel that there has been instances where the forcible conversion was happening with regard to marriages. So, even though there is a anti-conversion law and provisions given by the law to Indian citizen, that means nobody can forcibly convert. But if you're doing a conversion into from one religion to other uh, without any compulsion, it is perfectly normal. And India is a free country; you can follow your religion. But when it comes to the marriage, then you can marry interfaith without converting into any other religion. There was no compulsion. For example, a husband can have a religion and wife can have another religion, and they can practice their own religion as far as the Constitution of India is concerned and the liberty which has been given to citizens. There is no compulsion that for marriage you have to convert. But I think the love jihad has been brought in because there were in certain cases the forcible conversion were happening, and this was happening just before the marriage to be announced. So a partner gets totally confused because the partner is now getting married, and then just 1 hour or few 1 day before the marriage, it was conveyed to the partner that now you have to convert, otherwise the marriage will not happen. So I think these are the issues which were not covered in the anti-conversion law. That is why, in my opinion, as a layman, I feel that there was a need to bring this aspect also, uh, so that the people do not convert forcibly just for the sake of getting married. So, do you have an opinion on that from not only from the legal point of view but also from social angle?
Well, Chandrakant, actually, possible conversion certainly through misrepresentation or through inducement or allurement, as the act itself defines, would be unlawful. And therefore, such conversion would be bad, illegal, and would ultimately become an offense, wherein the punishment which is prescribed is from 1 year to 5 years. And forcible conversion of girls or of minorities or scheduled caste or scheduled tribes, the offense is even stricter. But with respect to interfaith marriages, there are two views because interfaith marriages has not always been encouraged or seen in a manner which is constitutionally permissible. Of course, two adults wanting to marry any person is their choice, and there can be no impediment or any restriction imposed by anyone. But we see in our social fabric that there are several hurdles which are created by family members or societal pressure, wherein such interfaith marriages or intercaste marriages are not easily been permitted. And we have also seen the consequences when, despite the adults wanting to marry, and if they marry by running away, then we have seen terrible instances where the Khap Panchayat or even the family members they kill their own kith and kin, and which is completely unconstitutional, impermissible, and it is extremely barbaric. So there needs to be protection of choice, freedom of choice, and liberty. So when two adults want to marry any person of any faith to their free will, there cannot be any impediment, and that should be clearly enforced and also protected by the state. And what we also see is that there was a survey wherein it was found that in last 1 month alone, there were 117 cases filed in the High Court uh, by couples who were wanting to marry or were married for protection, as they were threatened by their family members or other community members or religious members. And the High Court has throughout directed the senior superintendent of police and district police officers to act upon the complaints of the couples who are facing threat to life and liberty from relatives on account of their marriage outside caste or religion. And therefore, the high courts and the Supreme Courts have always upheld and protected this right of choice and liberty of every adult individual. And it also directs the senior officers to grant protection to such couples who want to live on their own free will. But yes, with respect to fraudulent marriages which are done by alluring or giving some monetary benefits or by way of illegal means, certainly that would cannot be also permitted at the same time. But but unnecessary restrictions, which I find in this act, is that it is not just that an advance intimidation is required to be given to the district magistrate. It is also that the permission is to be sought and inquiry is held, and the district magistrate in every case would find out through police means that whether the couple which is marrying or if there is any conversion that is happening through free will. So such I in my opinion this amounts to intimidation as well as interference uh, with your right to privacy and your right to choice. So every decision or every person who is trying to convert or trying to marry some other person from another religion is not through illegal means. So those who are legally trying to settle into their marriage, interfaith or intercaste, would not like such restrictions or such permissions to be obtained, because if I want to marry any person, I don't have to seek any permission from any other authority. So this authoritarian approach of the government, which makes me take permission before marrying, I find it a little intimidating and violating my right to privacy and the right to freedom of choice which I have. So that is one thing which is objectionable. Second is what is objectionable under the UP Act, and which is different from all other acts, is that the burden of proof. Now, so if any person who complains that this marriage or conversion is illegal, then it is not just that the victim who is being converted or who is being allured into marriage can only register the FIR or initiate prosecution. It is any person in his family member, it can be any blood relative uh, who has a right to lodge a first information report, that is the FIR, and initiate a prosecution, which I believe is also intrusive, because the victim, if there is a victim who has been lured into love jihad or has been converted through some fraudulent means, he can very well come up and say that I've been I've been fraudulently converted from one religion to another. But his parents, so suppose my parents do not want me to marry into another intercaste marriage, then even though it is within my choice and my right, and I am an adult wanting to marry, my parents or any blood relative or any community member can object and initiate a prosecution. That is one thing. Another thing which is objectionable, and the third thing is the burden of proof, which says that the burden of proof as to whether a religious conversion was not affected through misrepresentation, force, undue influence, coercion, allurement, or by any fraudulent means lies on the person who has caused the conversion, and whether such conversion has been facilitated by any person on such other persons. So the burden of proof is against the person who has caused conversion. Now, this is again also objectionable, because if I have converted some person in order to marry, and if that person has willfully and with her consent uh, uh, converted, but their parents object, now then, which causes an FIR and a prosecution, then I have to prove that this conversion is by lawful means and it is not unlawful means. Now this is so these are the three objectionable things in the act. Otherwise, uh, unlawful conversion, yes, is permissible and can be made an offense. There is no question with regards to that. But this act goes beyond the other acts which are passed in other states, and therefore this act is again challenged before the Supreme Court by some members of the community, and ultimately it is for the Supreme Court to decide whether this act is constitutionally valid or not. But there are some aspects which seem to be unfair.
Jeet, the way women were harassed, and some of the members of our society were harassed, forcing conversion just for the sake of marriage. See, when you marry somebody, you don't have to really convert into some other religion. But then there are certain citizens of India who are harassed to convert, otherwise marriage will not happen at the fag end of the celebration. So I think that is where that created a problem, and I think there were a lot of cases publicized, much publicized cases, also involving IS officers. Very senior people, well established, and part of bureaucracy, suffering because of this aspect. So I think a lot of people actually had filed complaints in the courts, and I think that is why this new provision has been brought in. See, as a layman, I don't see, if I have to marry somebody, I need to force a conversion, because if I love somebody, then I really love the person. I don't really love the religion of the person. So why there is a need to change? So I think that is where the fine line is, and I'm sure, as you're saying, that the Supreme Court will, uh, take a decision on that. But I think there was a social angle associated with it, where people were suffering. There were a lot of complaints for last many years, maybe 100 years, and finally, certain government chose that they basically will brought in the law to prevent it in some form or the other. I think that is where the way I understand is that this is basically to prevent conversion by promising a marriage. I think that is the only caveat here. And moreover, so if you basically say that, hey, I am willfully converting, there is no problem. You go ahead and marry. But if you don't know about that conversion aspect and you're getting into a marriage, and then at the fag end of the situation, you have been told that you have to marry because we will not marry until unless you convert, that is where the problem lies.
Right. To that you are right, because there is a difference between unlawful conversion and lawful conversion, and that has been clearly laid down in the act. So my only concern is that those who are lawfully wanting to settle by way of marriage should not be harassed only because there are certain elements who try to unlawfully take advantage. So that is the only concern. Otherwise, illegal or unlawful conversion is not permissible, also under the Constitution as well as under the Act, and therefore there cannot be any problem to that.
So
but they should not harry the persons who are on the right side of it.
I think your concerns are well taken and appreciated, because obviously the harassment should not be there, because two people are in love with each other and they're trying to marry. It should not lead to some sort of harassment. I think the legal fraternity will take a right decision. The matter is in Supreme Court. I'm sure the judges, honorable judges, will basically decide what is best for India. So
Absolutely.
thank you for finding time and discussing this very, very important subject and clarifying some of these legal aspects to our listeners and viewers. Jeet, thank you so much, and I will catch up with you next Tuesday.
Thank you very much.
Bye bye.